Joining us on the program right now to discuss this further is Mr. GT Ogunye, who is a lawyer. Mr. Ogunye, thank you very much for joining us on the program. The biggest talking point on the arrest of these judges has been whether the DSS actually has the right to arrest the judges. I mean, we want to get your take on that. I mean, does the DSS actually have the right to arrest these judges? Because what we've heard from the NBA and from some other lawyers is that what ought to have happened was that the matter should have just been left for the NJC to deal with.
Well, thank you, DEJI, for inviting me on your program again and for discussing, to enable me the opportunity to have a discussion of this matter. Now, there is no law, to my knowledge, where specific power to arrest judges are donated to any law enforcement agency. The police, for example, are not given specific powers to arrest judges. The FCC are not given specific powers to arrest judges. The SCPC are not given specific power to arrest judges. What laws generally do, penal legislation or law establishing law enforcement agencies or security agencies do, is to give these agencies or bodies general powers to prevent commission of crimes, detect commission of crimes, investigate commission of crimes, and prosecute commission of crimes as the case may be. And so the SSS, which is now styled the Directorate of State Security Service, but which is known to law as the State Security Service, under the National Security Agencies Act, Cap N74, Volume 11, Laws of the Federation of Nigeria 2004, has provision empowering the SSS to do certain things. Here I refer to Section 2, Subsection 3, Paragraph ABC of that Act. And it's a small act, altogether having 8 sections. It's indeed a slim legislation. The portion of the law I refer to empower the SSS to prevent and detect all crimes within Nigeria. All crimes within Nigeria that threaten our national security. Now, the SSS is the domestic counterpart of the NIA, for example, which is the National Intelligence Agency, also provided for in that act, because the act, established 3 agencies: the Directorate of Intelligence Agency, which is the DIA, of Military Intelligence, Directorate of Military Intelligence, DMI, SSS, and then the NIA. Now, and Paragraph C provides that in addition to the 2 functions of the SSS, being prevention and detection of all crimes within Nigeria that border on subversion of national security and handling of all classified materials and preserving them, that in addition to these 2, the SSS can be given the additional responsibility by the President or the National Assembly on matters that the President of the National Assembly deems to be a matter of concern to national security. So it's indeed a very small law with broad scope. And keep in mind that between 1999 and now, there has not been an attempt to narrow the scope of its operation by the National Assembly that has the power to do that. Keep in mind that it was a law that was made first as a decree by the military when the military was in power in Nigeria. So that's what the law provides for. And I have interpreted this law this way. Corrupt practices or corruption in the judiciary that threaten to submerge or subvert or destroy the judiciary as the third arm of government in Nigeria, indeed can be deemed to be a national security issue. Because government, as you know in Nigeria, has three arms: the legislature, the executive, and the judiciary. So if you have corrupt practices that threaten to destroy the National Assembly or the executive branch of government, yes, you can say that there are anti-corruption agencies that are charged with the function of investigating corrupt practices like the ICPC and financial and economic crimes and money laundering like the EFCC. Yes, you can say that, or the police that has the general powers to investigate all sorts of crimes. But you cannot, given the interpretation I've offered, then say that the SSS will not have the power to deal with that. And so, in my own assessment, contrary to what the NBA is saying and some lawyers have said, the SSS has the power to take on this matter, which indeed is a very serious matter in the judiciary. The second issue is the issue that has to do with the manner of arrest, whether it is legal, whether it is authorized by law and all that. We can get to that. By the way, before I just stop on that, it is interesting that people are saying that the SSS does not have this power. On Sunday, when the news broke, the media was awash with all sorts of headlines using such words that convey the imagery that we are having a dictatorship here. And I just laughed. Buhari boys have gone crazy. Wike foils attempt to abduct a judge. Use the language. A governor that obstructed justice, that prevented federal agents from arresting a judge, another federal agent, that impeded federal agents in their work, is now the one that is celebrated by the media as foiling an abduction. So they call or label an arrest an abduction, and they call the act of the governor an act that foils something that is terrible. So look at the casting. But now, yesterday, today, I think that the media is pulling back, perhaps because fuller details, fuller information are now coming on board. Now, how do you say that a body that prospective judges, those who are to be appointed to the bench, and those who are to be elevated to the higher bench, Court of Appeal, Supreme Court, those who are to be appointed, a body that they voluntarily submit their credentials to for security screening, does not have the power to ask them questions bordering on the issue of corruption. So if what they are doing had no security implication, why would they submit why would they surrender to security screening? They have nothing to do with security now. They have nothing to do with internal security of Nigeria. So why would judges do that? That is the point. And secondly, only recently, and I've said it elsewhere, very interesting point. Around Delta Edo axis, there was a notorious criminal gang that was perpetrating horrendous kidnapping there. About the same time, Chief Mike Ozekome, Senior Local of Nigeria, was kidnapped by that gang. And not long thereafter, or about the same time, the wife of a serving justice of the Supreme Court was also similarly kidnapped. That wife is a lawyer, reputable lawyer, known in the legal profession, a consummate arbitrator, was kidnapped. And that was a sad incident. You know those who bust that ring? The SSS. They were the one who apprehended those criminals, not the police. And I didn't hear Chief Michael Zekome or anybody in Nigeria then saying, kidnapping was not listed in the SSS Act as in the National Security Agencies Act as one of the issues that threaten national security. Why should SSS be dabbling into the issue of kidnapping? Nobody said that then. That's the duplicity, the hypocrisy, and the double-speak that pervade this kind of discussion. You don't need to list what the SSS can do item by item to then begin to wonder whether they can do this or not. Although I am of the view as a lawyer that at the point that act may be subjected to judicial interpretation to see whether the judiciary can then limit the scope of its operation by its own interpretative jurisdiction. But until that happens, or until the National Assembly amends that act to narrow the scope of its operation, you indeed cannot fault what has, you can't fault what has happened.
Okay. Let me ask you another question. I mean, very important here. Let me ask this. Should it be the case that, you know, if a judge is suspected to have committed, you know, a crime, that the normal thing would be to report to the NJC? And what exactly does the NJC do? Does the NJC discipline judges for breach of their ethics or for committing, you know, allegedly committing crimes?
You know, I thank you, DEJI, again for that question. It's absurd that some people are suggesting that a security agency like the SSS or the EFCC or the police should first report the criminal conduct, alleged criminal conduct of a judge to the NJC before moving on that judge. The NJC is not a court. The NJC does not have the mandate under the Constitution to investigate crimes or punish for crimes. The NJC does not even have the resources to conduct an investigation. So if the NJC were to be the body that were to call those judges to question, what would the NJC have done, for example? Would the NJC have carried out a sting operation to arrest those judges? Does it have a custody? So give me a break. What are people talking about? The NJC, pursuant to Section 153 of the Constitution and the first part of the third schedule of the Constitution, I'm referring to paragraph 20, 21, and 22, that defines the composition of the NJC and its powers, deal with discipline of judges regarding acts of judicial misconduct in an administrative capacity. And what are the punishments that they award? Suspension of judges, recommending dismissal of judges. These are the only things that the NJC can do. So if a judge is a notorious bribe taker, for example, and there is credible intelligence and evidence that that judge has turned his house, which ordinarily should be a forest of law books, into a bureau de change. So what is the NJC going to do about that? That's an allegation of crime which the anti-corruption agency or security agency can investigate and deal with. As a matter of fact, I'm of the clear view that given the unprecedented nature of what has happened and the risk involved, the sophistication involved, the step that has to be taken, this operation could only have been carried out by a secret service agent or agency. What do? You go to the police that we know. that big police, that police of 350,000 people, that is an organization where information leaks, you go to them and then say, we want to go and bust a judge. What do you suppose will happen? Or you go to a high court judge, brandish a warrant, you want to go and arrest a Supreme Court justice. So before that day will end, before the sun sets that day, that judicial day, that judge will have had. And that evidence will have been removed from there. So what are people really talking about? Do you want a country? You want to make an omelette, you don't want to break an egg. So what exactly are these persons who are naysaying, who are saying that this is, what do they want?
Let me just quickly ask you this sort of double-barrel question now, if you like. First is, there's this argument from some people that, you know, these raids should not, the arrest should not have been conducted at night, that, you know, the DSS could have just gone to these houses, you know, during the day and not the kind of operation it launched. And then secondly, how damaging is this for our judiciary?
Well, I answer those two questions quickly. First, by the provision of the Administration of Criminal Justice Act, and I reference section 148, search warrant or warrant of arrest can be executed at any point in time, including a public holiday or a Sunday, any day, anytime, 1 a.m., 2 a.m., anytime at all. So the impulsive and spontaneous condemnation by some senior lawyers to the fact that they went there at an ungodly hour has nothing to do with the law. The law doesn't support what they are saying. You can execute it at any time, and that's not a problem. And section 149 also talks about if you want to gain entrance, if the security agency or law enforcement agency wants to gain entrance and they are denied entrance, they are permitted, having regard to section 9, 10, 12, and 13 of the same Administration of Criminal Justice Act, to break the outer wall, inner wall, outer window or inner window, or even the wall of that building, or an adjoining building, in order to be able to effect arrest or conduct a search. That law was made in 2015. I didn't make it. That's the language of the law. Perhaps those who are complaining about this have not updated their knowledge of the law. That's as to the mode of arrest. And as to the second aspect of your question, which relates to how damaging this is to the judiciary, I don't think this is damaging to the judiciary. This is an attempt to save the judiciary from destruction. So this is not an attempt to kill the judiciary, because I take the view that the face of the Nigerian judiciary is not the face of corruption. Look, there are judges in Nigeria who work themselves to the bones, discharging their duty, delivering rulings. They have no life, social life, outside their work. They are diligent, they are not corrupt, they have integrity. So they are in the majority. So if you then have a miserable minority, like a cancer, that has to be excised from that body, why should anybody celebrate that as the face of the Nigerian judiciary and give the impression that they are in the majority? Indeed, when you rally around them and then say that the judiciary is the one that is being destroyed, you give the impression that the Nigerian judiciary is known for corruption. No, that's not what it is. So the Nigerian people should continue to repose hope in this judiciary, because there is no other body that is established by law to serve as an arbiter and resolve disputes between government and government, government and person, and person and person. It is still judiciary. So inevitably, inescapably, we still have to deal with this judiciary. So we cannot sidestep it. And so I argue that this is an attempt to save the judiciary. It's not an attempt to destroy it. The judiciary, still compared to the two arms of government, is the only body that engages in self-cleansing, even though we say that it's not flourishing enough, because you can't just retire somebody and say go home and enjoy your money without turning the person in so that I can face the music, because of the principle of equality of all before the law. As a matter of fact, I volunteer to state that before an ordinary citizen should go to jail for infraction of law, a judge that deliberately breaks the law should be the first person to go to jail, because the scale is higher. So you cannot just say, go away and sin no more, or go away and enjoy your loot, without bringing to the threshing floor of the judiciary. So hopefully, this attempt that is being made, we hope it will be sustained, will demonstrate that after this storm, people will have the confidence that, oh, these corrupt few that are threatening the survival of the judiciary have been weeded out of the judiciary. And then they can then look at the judiciary and say that, now we have confidence in it. The bad ones are gone. The bad heads have done. And Nigeria can heave a sigh of relief, just in the same manner they did in 1999 when implementing the Ensure panel on judiciary. President Olusegun Obasanjo summoned the courage, although he wasn't the one who authorized it, Abacha did, summoned the courage to dust it up and then look at that recommendation that 47 judges should be expelled from the judiciary, and many of them were expelled from the judiciary on that occasion. That did not undermine confidence in the judiciary. That strengthened confidence in the judiciary, and I hope that this one will also strengthen.
We just have to end it there. We thank you very much for your contributions, as always, and I will take a short break, and when we come back, we'll be talking to someone else. Every day, every hour, and every minute, news break in Nigeria. Things happen so fast, it's most times difficult to track and comprehend them. But that's what we do right here on DEJI360. 2015, would you want to come back again?
It's like asking Jesus Christ if he knew he was going to die, will you want to come back as the savior of the world again?
We do not just help you track the stories, we break them down, explore all the angles, analyze the issues so that you can fully comprehend the stories and use them to make the right decision.